Here is our last case, which will help us understand several other nuances and aspects of the offense of culpable homicide. The facts of the case are as under. The accused in this case gives a person some halwa, a sweetmeat, in which a poison containing arsenic and mercury had been mixed, and the intention was to kill this person. He ate only a portion of the sweetmeat and he threw the rest away since he did not like the taste. A girl aged 8 years who was a niece of the accused took some of this thrown away sweetmeat, ate it, and gave some more to another little child who was also nearby and who ate it. The two children who had eaten this poisoned sweetmeat died from the effects of it, but the person for whom this poison was meant, the person who was intended to be killed, he eventually recovered. The question is the accused guilty of the offense of culpable homicide for causing the death of these two girls? Before we can answer this question, we have to settle certain important issues. This is issue number 1, contributory action of the victim. We find in this case that there is contributory action of the girl in picking up the sweetmeat and eating it. What is the effect of this contributory action of the girl? We find the answer from the first illustration to section 299. It is clear from there that contributory action by the person whose death is actually caused will not necessarily prevent the act of the offender from being culpable homicide, even if the death could not have occurred without such contributory action. Here is the second issue, contributory action of a third party. In this case, there is contributory action of the person for whom the sweet was meant, the person who was intended to be killed, in throwing away part of the sweetmeat. So the question is, what is the effect of this contributory action by a third party? And the answer is clear from the second illustration to section 299. Which shows that contributory action by a third person will not necessarily prevent the act of the offender from being culpable homicide, even if the death could not have occurred without such contributory action. And then the last issue, remoteness of the cause. The question is, can it be properly said in this case that the accused caused the death of the girls in the ordinary sense of those words? Was not the accused connected with the deaths too indirectly or too remotely? And here is the answer. Action of the accused was the efficient cause of the girl's death. Efficient cause. Action of the accused was the efficient cause of the girl's death, though her own action in picking up and eating the poison was also necessary in order to effect her death. There is contributory action by the girl herself, but as we have seen, this situation is fully covered by the first illustration to section 299. In that illustration, the man who laid the turf and sticks over the pit with the intention of causing death has been held to be the cause of death of the man who ignorantly fell into the pit. Although death would not have occurred if he had not of his own free will walked to the spot where the pit was. Death could not have occurred without this contributory action by the victim. It was the victim who himself walked to the spot where the pit was. But still, the illustration says that the person who laid the turf and sticks over the pit is responsible. He is the cause of the death of this person. And now the last question. What about the mens rea? The mens rea, which is essential to criminal responsibility of culpable homicide, existed with reference to the act done by the accused in attempting to kill the person to whom he had offered the poisoned halwa, though not in regard to the girl whose death he in fact caused, and that is all that the section requires. As I have been repeatedly emphasizing, it is not at all necessary that the guilty intention should be directed towards that person whose death is actually caused. It is sufficient if death is actually, even though involuntarily, caused to one person by an act intended to cause the death of another. It is the criminality of the intention with regard to the latter that makes the act done and the consequence which follows from it an offense. So the decision in this case is clearly an affirmative answer. Yes, the accused is guilty of the offense of culpable homicide for causing the death of the two girls. This is also a real life case. The citation of the case is Emperor versus Musnuru Satyanarayan Murthy, decided by the Madras High Court once again in the year 1912. Having understood the concept of culpable homicide in all its aspects from these three cases, it should not be now very difficult for us to answer this often asked question: is a man guilty of culpable homicide if he shoots at a living human being, believing him to be dead? The answer is a clear no. The reason is that the intention of the accused must be judged not in the light of the actual circumstances, but in the light of what the accused supposed to be the circumstances. It follows that a man is not guilty of culpable homicide if his intention was directed only to what he believed to be a lifeless body. And now we come to the punishment for this offense of culpable homicide. There are three components of mens rea in section 299: intention to cause death, or intention to cause such bodily injury as is likely to cause death, or knowledge that the act is likely to cause death. The punishment will depend upon which component of section 299 will apply to that particular case. Where there is intention to cause death, the first component is intention to cause death. Where there is intention to cause death, the offense of culpable homicide gets aggravated and it gets converted to the offense of murder, and the punishment is either death or life imprisonment under section 302. Where there is intention to cause such bodily injury as is likely to cause death, this is the second component. Then the offense of culpable homicide is punishable under the first part of section 304, and the punishment there is imprisonment for life or imprisonment of up to 10 years and fine. So imprisonment is a must. Along with that, there can be a fine also. This is the third component, the knowledge. Where there is knowledge that the act is likely to cause death, but there is no intention specified in section 299, then the offense of culpable homicide is punishable under the second part of section 304, and the punishment for this culpable homicide is imprisonment of up to 10 years or fine or both. No life imprisonment. Thus, there are three types of punishments for culpable homicide. The Indian Penal Code practically recognizes 3 degrees of culpable homicide for the purpose of punishment. The first is what may be called the culpable homicide of the first degree. This is the greatest form of culpable homicide, which is defined in section 300 as murder and which is punishable under section 302. The second may be termed as culpable homicide of the second degree. This is punishable under the first part of section 304. And then lastly, there is culpable homicide of the third degree. This is the lowest type of culpable homicide and the punishment provided for it is also the lowest. Culpable homicide of this degree is punishable under the second part of section 304. We can say now that it is the degree of probability of death which determines whether a culpable homicide is of the gravest, medium, or the lowest degree. With this, we conclude our study on the offense of culpable homicide as defined in section 299 and as made punishable under section 304.